Getting a divorce? Find out the legal system's best kept secret to making the process easier and the outcome happier. Only on Toronto Speaks Legal Advice. Welcome to Toronto Speaks Legal Advice. I'm your host, Natalka Falcomer. Tonight we're discussing what you need to know about family law. I have the pleasure of welcoming into the studio tonight one of Toronto's best family lawyers and biggest advocates for simplifying the legal process. We'll be speaking with Andrew Feldstein, a family lawyer who was honored with an inaugural appointment to the Dispute Resolution Officer panel for Newmarket. Andrew sits on various committees aimed towards reforming family law. He mentors law students and is frequently interviewed by the media because of his expertise in family law and collaborative law. Thank you so much, Andrew, for coming on. I'm so excited to be back in our third season to help people understand the legal system, and that's something that you're a big supporter of. And I want to start right off the bat with that. In September 2013, you launched something called It's Time for Justice. It was an advocacy campaign. Can you explain to me why you launched this? What is this all about? And what are you doing to help make the legal system, or at least push for it, a bit easier?
Well, the frustrating thing is that when you are a family law lawyer, you see how much waste can take place in the process. What you're hoping to do and hoping to achieve is to make the process simpler and more efficient for people, so that way they can spend less on legal fees, get to a resolution, and hopefully move on with their lives. Because the longer the dispute lasts, the more challenging it is for two parties to co-parent for the rest of their lives with their kids.
Of course, that's something that you see as a big issue, and we're seeing a lot of changes within the legal system as well, where we're moving away from a court focus to something called collaborative law, which I want to touch upon in a second. But before we do that, I really would like to know a little bit more about the best interests of the children. This is a white paper that you published that is also goes along with the same sort of theme of increasing access to justice and also protecting the children. Can you tell me what this is all about? This was released in October 2014.
Well, the title really sums it up. It's in the best interest of the children. Because what a lot of people have to think about when they're entering into the family law arena and they're entering into the dispute is what's more important to them? Striking out at their former spouse and winning some small battles? Or is it more important to put your children ahead of your own interests and try to reach a resolution? In order for that to work, you need two sides to work together to achieve that objective. And hopefully, most families can achieve that objective, but not all of them can.
Of course, and this is a perfect segue into talking a little bit about collaborative law. And before we do, I just want to invite our callers. If you're going through an ugly divorce, if you need help in dealing with custody-related issues or understanding how to solve some of your separation-related problems, please give us a call. And Andrew, of course, one thing that I want to get to, this whole collaborative law approach. What is collaborative law in the family context?
Well, that's a great question because there is some confusion. And there are certain principles that happen in collaborative cases. The first principle is that you have to sign a participation agreement. And that participation agreement needs to be signed by both the parties and both of the lawyers. One of the key ingredients there is if there is a breakdown in the negotiation and the matter has to go to court, the lawyers have to withdraw themselves and the case needs to go to new lawyers. And you may say, well, why should the client have to pay to have a second lawyer learn their file? Well, that's part of the motivation of keeping people within the collaborative process. Now, I believe there are some cases that are appropriate for collaborative law.
Like which ones would be a good example of an appropriate case?
Well, first of all, parties need to be able to really work together and want to reach a resolution. So it can't be a high conflict case. And in a lot of situations, you have to be very careful when one party has significant power over the other party. Usually that would be financial, such as one side is self-employed, has a lot of income, and can control the documents that are needed in order to resolve the case.
What do you mean controlling the documents? So this is something that you always hear is a problem when it comes to separations, divorces, etc. What documents are we talking about?
Well, I'll take a step back in order to answer that question. I frequently will have people come into my office and they say, how much support am I going to get? How much money am I going to get? And that's predicated on how much money one spouse makes and how much money you make. And we have to figure out how much each side makes and how much they have. Well, If someone is an employee at a company, that's easy. You see their T4, you see their tax return. But if they're self-employed, it's not easy because they may be putting a lot of personal expenses through the business. And you have to untangle potentially a web of various companies, trusts, personal expenses to understand what their income is. And if you're in the collaborative process, and I've seen it too many times where people go through the process, sign an agreement, and then afterwards regret signing it because of this power imbalance where the side who has control of the documents has more money, make sure that they spend $10,000 or $20,000 in legal fees to get nowhere. And then they feel they have to sign the agreement. So collaborative family law can be a wonderful thing when there isn't the power imbalance and both sides want to work towards resolution. And I've seen it do a phenomenal job of resolving disputes, but you have to be careful to pick the right case from the wrong case for collaborative family law.
Of course, to our callers and viewers at home, if you have a question about whether or not the collaborative process or the regular process is for you, give us a call and we'll help answer that question. So it's not always less expensive, because I thought that the collaborative process would be less expensive. Something that you mentioned, that you can rack up fees if there's that power imbalance. Who else is also involved in the collaborative process?
Well, you can end up building quite a large team. So you start with at least one lawyer on each side. You probably will have a social worker that's going to work with the parents and the children to develop a parenting plan or a schedule for when the children are going to go back and forth. In addition to that, you may have a financial advisor. The financial advisor can be a CA, a chartered business valuator, and sometimes you need other experts to be involved. You may have a real estate appraiser if there's various pieces of real estate involved. But one of the advantages with that, because some people may say, wow, that sounds like a lot of money, is you're hiring people jointly, so there isn't going to be a battle of experts.
Right.
And if you take the example of a social worker, do you really want to be having your lawyers dealing with the parenting plan, or would you rather be dealing with it on your own with someone who's trained mental health issues to work with you and the children?
So it's better for children in that sense as well, because you can bring in the parties that are best suited.
Absolutely. Much better for the parties if they can work with the social worker and resolve a schedule.
So what would happen if one party wants to go to court and the other one doesn't, but they had signed this agreement, and we have about 90 seconds left?
If they've signed the agreement, either side, as part of the agreement, has the ability to withdraw from the process. And if they withdraw from the process, both lawyers can no longer continue, and then they will have to hire new lawyers and go to court.
Okay, so there's that situation that if one withdraws, and basically it makes it that both have to withdraw as well.
Absolutely.
Any final words on the collaborative process? Any nugget of good information?
Be careful that you are going to a qualified collaborative lawyer, and if you're going to do it, make sure it's the right type of case where you don't feel there is a strong power imbalance between both spouses.
Okay, wonderful. Thank you so much again for answering those questions. And of course, to our viewers at home, if there's anything that you need to know about family law, we certainly have Andrew that is available to us. And before we go to that, just one drawback about mediation, or rather collaboration. Is there anything apart from the imbalance of power that you could sort of say is another drawback of the collaborative process?
I think the process can be wonderful because it takes into account each side's interest, and it's supposed to be interest-based negotiation. And as a lawyer, it's important in negotiation to understand what motivates the other side, what's important to them, and it allows both sides to put that on the table, to understand what's important, so you can get to a resolution.
Perfect. Thank you so much. And we're going off to break right now. When we come back, you'll not only watch lawyers do something incredible, give away legal advice with no bill, but you'll also get the insider tips you need to avoid a needlessly expensive and emotionally damaging divorce or separation.